on December 17th of 2019, a proposed order in the matter of Mr. Rood was issued. As a result of those proposed orders, the administrative law judge upheld the allegations set forth by the division and proposed regarding Alameda Electric a civil penalty of $5,000 and a suspension of its electrical contractor license for 12 months. In the matter of Kyle J. Rood, the administrative law judge issued a proposed order proposing Mr. Rood pay a civil penalty of $6,000 and revoking Mr. Rood's supervising electrician license. And regarding Mr. Hepler, the administrative law judge issued a proposed order directing Mr. Hepler to pay a $2,000 civil penalty. In response to those proposed orders, which you'll have attached, counsel for respondents filed exceptions, which you have for review. The division is putting forth these proposed orders for your consideration and direction to staff at your consideration as to whether or not to adopt those and direct staff to issue final orders consistent with the administrative law judge's proposed orders. Sarah, do you have anything to add that I might have missed?
I don't, no.
I believe counsel for respondent, all three respondents, Mr. McLaughlin is on the phone as well. Mr. McLaughlin, do you have anything?
No, I believe my exception fully summarized in the shortest possible time my issues with the proposed order.
All right. Thank you, Mr. McLaughlin. Madam Chair and members of the board, do you have any questions for me as division counsel with regard to anything that's been presented to you or that you've reviewed in regard to these matters?
Madam Chairman, I had a question. I was wondering why we have an Assistant Attorney General presenting this at this time rather than just the contested case representative. Is there something special, different about this? This is Tom Kyle, by the way.
That sounded like it was a question for the chair, but I'm hoping that Mr. Anderson can answer it.
Oh, certainly. Just given that, in this particular matter, given the unusual circumstances where obviously we can't meet in person, and since both parties were going to be, since counsel for respondent was available to be present today, we just thought it best that the presentation be handled. We just thought it best that the presentation be handled by me for these particular cases.
And through the chair, this is Sarah Bloom-Linville. Just to further explain, Mr. Anderson represented these cases at the hearing as well, which is another reason why he's presenting them today.
Madam Chair, this is Thomas Kyle. I've kind of reviewed these documents, and I personally know Kyle Rood. I don't know Alameda Electric. I haven't seen Kyle for quite a few years, but I do know that he's been really involved as a instructor on code and other items. And I guess I'm fine with the fines, and I think that should be paid. And I'd like to propose that perhaps we allow Kyle and Alameda Electric to retain their license under a provisional, no other violations for a 2-year period, and that they report back to the agency during that period on all the work that they have going.
Is your request that the business does not have the suspension that's recommended of 12 months?
That's correct. That we allow them to keep their licenses, but we put them on probation for a 2-year period. And the fine should be as what's requested for all three.
This is Ryan Richards. I know Kyle Rood, and I know that he is, considered an expert in code and whatnot. So I feel like Alameda probably relied on his knowledge, and maybe they were led a little astray, thinking that Mr. Rood was considered an expert and knew, and so a 12-month suspension for their contracting license seems like maybe they were just led down the wrong road.
Madam Chair, I'll go ahead and turn this into a motion. This is Tom Kyle. For Dustin Hepler, and I don't know if you want to take these one at a time, but for Dustin Hepler, I will make a motion that we proceed with the fine of $2,000 in his case.
We have a motion to proceed with. I might need somebody from the division to help me out with wording this, but just to proceed with the fine for Dustin Hepler.
Correct, the proposed fine of $2,000.
We have a motion. All in favor, say aye.
Madam Chair?
Or actually, Debbie has to do that, right?
Yes, please.
Okay.
I second the motion. This is Ryan Richards.
Well, before we go into the vote, if I may ask Sarah, were you good with this motion? Or do board members need a little help? Sorry, board members.
As long as they vote on them separately, they can vote however they choose, Debbie.
Okay, great. I'll proceed with the roll call vote. Randy Smith?
Aye.
Ryan Richards?
Aye.
Britton Pomrose?
Aye.
Robert McNeil?
Aye.
Scott Hall?
Aye.
John Flagle?
Aye.
Randy Carmody?
Aye.
William Barlow?
Aye.
Vice Chair Thomas Kyle?
Aye.
Chairperson Heather Miller?
Aye.
Motion passed unanimously.
Okay, so we have 2 more items on, or 2 more motions required on this, one for Kyle Rood and one for Alameda Electric.
Correct.
So, and if I can stop real quick, can either Sarah or Tyler say what the order is for Kyle Rood and what the order is for Alameda Electric one more time, please?
Certainly. So the proposed order of discipline, and Madam Chair, do you prefer these in any particular order since the votes are going to be broken out separately?
No.
Okay. Thank you. The proposed order for Kyle Rood is a proposed civil penalty of $6,000 for violations of OAR 918-282 01402C, D, E, and F. In addition to that civil penalty, the proposed order imposes a revocation on Mr. Rood's supervising electrician license number 4871S, commencing on the date of entry of a final order in this matter. In regard to Alameda Electric, the proposed order proposes a discipline of $5,000 on Alameda Electric for violations of OAR 918-282-00101 and OAR 918-282-0120 sub 1. In addition to those civil penalties, the proposed order proposes a suspension for 12 months of Alameda Electric's electrical contractor license number C923. And again, that's a period of 12 months commencing from the date of entry of a final order in this matter.
Thank you for that.
This is Ryan Richards again. Just to clarify my comments earlier, I feel like Mr. Rood is considered an expert, and I feel like he knowingly did the wrong thing for several years while employed in court, and you know, a fine and a license revocation seems legitimate in my eyes. I don't know about the contractor, Alameda Electric. I don't feel like they should be run out of business because they were essentially led down the wrong path. So I do support the state findings with regard to Mr. Rood, but I personally don't think that Alameda should be put out of business for their part.
Oh, Madam Chair, may I address the board? This is Assistant Attorney General Anderson.
Yes.
Just a couple points of clarification. With regard to Alameda Electric, their license is not being revoked. It is being suspended. The proposed discipline is a suspension for 12 months, not a revocation. Just to be clear on what the scope of what the scope of the penalty is for the board's evaluation. In addition, when division staff reviewed these matters with DOJ, the sanctions sought by the Building Codes Division were consistent with previous agency practice in similar cases, if that helps at all with the evaluation.
Well, that is my concern, is stepping away from what we've done in the past and opening things up for the future. The expectation is the contractor understands the rule of law of the business that they're in. We can split. It doesn't matter. We can continue talking about them together, or we can. Someone can make a motion on Kyle Rood prior to discussing Alameda.
Through the chair, this is Randy Smith. My opinion is that the contractor, it is their responsibility to know the rules. It is their responsibility to abide by those rules. I also feel that Kyle Rood would know as well as anybody, or more so, the rules, and that it is, also his responsibility to abide by those rules. I find it very, very hard to believe that the people involved in all of this were unaware that they were not, at the very least stretching or bending or taking advantage of the rules. So I I am in favor of all the findings and the penalties and the suspensions, all of that. I feel that, we've put these people in charge to go do their job, to do these investigations, and I feel like they did a good job. I think they're right on with their findings and their recommendations.
I, Ryan Richards, would like to make a motion to support the findings with the state and approve Kyle Rood's case.
Ready for
Okay, the motion is to carry out the order and the findings of the division.
Okay, I'll take a roll call vote. Randy Smith,
Aye.
Ryan Richards,
Aye.
Brennan Pomerose,
Aye.
Robert McNeil,
Aye.
Scott Hall,
Aye.
John Slagle,
Aye.
Randy Carmody,
Aye.
William Barlow,
Aye.
Vice Chair Thomas Kyle,
Aye.
and Madam Chairperson Heather Miller.
Aye.
Madam Chair, we have unanimous approval.
Okay, so we're on to the last issue before us in the report about Alameda Electric. Does anybody have anything that they want to add to the discussion? Or a motion?
Through the chair, this is Bert Pomerose. I was just wondering if we suspend the contractor's license for what's been done. I think that kind of harms the employees that are working for Alameda Electric. So is this motion going to put Alameda in a position where they can't continue business for this period of time?
Are you asking? You said through the chair, so I didn't know. Are you asking the
Yes,
Assistant Attorney General?
To the Attorney General.
Oh, thank you. Sorry, Madam Chair. I just wanted to make sure we did that properly. To the board members, and appreciate the question. So, if you adopted the proposed discipline, Alameda Electric's license would be, the electrical contractor license would be suspended for 12 months. So, if that suspension were imposed and upheld, that the electrical contractor license of the business would be suspended for 12 months. None of those penalties attach to individual employees. So while employees could find work elsewhere, in terms of electrical contractor work through Alameda Electric, for the 12 months the suspension were imposed, Alameda Electric would not be able to engage in activities under that license and utilize employees for fulfillment of that role. That being said, the employees themselves could perform activities. Additionally, and while I can't speak for Alameda Electric on this, they do have Alameda Electric does have available to it the right to, as do all respondents, the right to appeal the discipline at the appellate court level. So this would just be an imposition. This would just be the adoption of a final order at the administrative level and then go forward from there. Does that answer the board members' questions, or any more clarity needed on something else?
Yes, this is Vern Palmrose. That does answer my question. Thank you.
All right, thank you. Thank you, Mr. Palmrose.
So for me, I agree with Randy Smith. I mean, that we have the expectations of the signing supervisor, we have the expectation of the contractor, and I would like to continue to be consistent with the way that we've ruled in the past. And as the Assistant Attorney General pointed out, there's still a path to appeal for the contractor.
This is William Barlow. Going back to Mr. Anderson's comment, can you clarify that no individual associated would have penalties associated with their individual? So could they theoretically reorganize, not harming the employment of other members of the organization were qualified to fill the role of supervisory electrician?
Through the chair, may I answer Mr. Barlow's question?
Yes.
All right, thank you, Madam Chair. Mr. Barlow, thank you for your question. So, and please ask me to clarify if I don't hit it exactly on the head of what you're asking. I think I have an idea of what you're phrasing. You were pretty clear, but just let me know if I'm not getting you all the way there. So the suspension that is being proposed would attach only to Alameda Electric's electrical contractor license. Alameda Electric as an entity. There are no penalties being attached. Well, excuse me. Mr. Rood and Mr. Hepler in separate disciplinary cases had penalties and discipline that was proposed. No other individual employee of Alameda Electric has any discipline that is being proposed or that would attach to them. Now, as far as reorganize, I might be a bit confused of what you mean. Alameda Electric would have the suspension imposed. The individual employees, if they wanted to either work for another contractor, apply for licensure as a collective and do something on their own, they have the whole range of licensed activities available to them. This discipline that is being proposed only with respect to Alameda Electric's electrical contractor license C923. Mr. Barlow, does that answer your question, or did I miss the mark a little bit there?
No, you answered the question clearly. Thank you.
Okay, thank you.
Madam Chair, Randy Carmody, I move that we follow the recommendation of the proposed against Alameda Electric.
This is Randy Smith, I second.
Okay, I'll go ahead with the motion. Randy Smith?
Aye.
Brian Richards?
Aye.
Brennan Palmrose?
Aye.
Robert McNeil?
Aye.
Scott Hall,
Aye.
John Flagel,
Aye.
Randy Carmody,
Aye.
William Barlow, William Barlow,
Aye.
thank you. Vice Chair Thomas Kyle,
Nay.
Chairperson Heather Miller, Madam Chair, I assume you're debating? Heather Miller,
Yes.
you're,
Sorry, I was on mute.
and you have said yes to the motion?
Yes, I apologize. I was on mute.
No, oh, sorry, no problem. But the motion does pass.
Thank you. And we're moving on to agenda item 3B, the board vote on consent orders for cases. Sarah Blenwinville again.
Yes, good morning, Chair Miller, members of the board. For the record, Sarah Blantonville, contested case representative for the division. Before the board is the summary of consent orders recently negotiated by the division on the board's behalf. There are 3 cases there since our last meeting. They all fall within the penalty matrix guidelines. Board action is required on these cases. They're all fairly standard. There's just one that I want to point out in particular. It's Monolith Systems, case C2019-0139. That one's a little bit unusual because we didn't find any actual evidence that they had completed any work in the state of Oregon, but they had bid to do a residential tram in Oregon for certain and employed locally licensed companies to do varying work. But clear that on their website they had some references that would be misleading, allowing people to think essentially that they had a license and an opportunity to perform the work in Oregon. So as part of their consent order, we had them take all of that language out and off of their website. And of course, they are agreeing to not perform any more work in here without obtaining an electric contractor's license. Everybody else, including them actually, is a first-time violator, and I am available to answer any questions that anyone might have.
Through the chair, Randy Carmody. Why was the fine for the elevator work 25%, reduced to 25%, while the others were only reduced to approximately a third?
So there was only the one violation. The others had multiple violations. So it just works out a little bit different for the penalty matrix. That was one that was negotiated by Tyler Anderson, and they were a first-time violator. So I think that, again, the penalties that were suspended still fall within the allowable amount on the penalty matrix. But I think it just appears more because there's only one violation with Monolith, but there were several violations with the other companies. So it just works out to be a little bit different because we have minimums we can settle for.
Okay, I was just curious because I had calls from multiple homeowners complaining about this incident.
Definitely understand that. We spent a lot of time investigating this case and looking into it.
Okay, thank you.
So, very seriously.
I, Ryan Richards, would like to make a motion that we approve the staff's consent orders.
Debbie, will you take a vote?
Yes, Madam Chair. Randy Smith,
Aye.
Ryan Richards,
Aye.
Bruno Pomerose,
Aye.
Robert McNeil,
Aye.
Scott Hall,
Aye.
John Flagel,
Aye.
Randy Carmody,
Aye.
William Barlow, William Barlow? Did we lose William Barlow?
You hear me?
And your vote is? I'm sorry, would you repeat that?
Yes.
Okay, thank you. Vice Chair Thomas Kyle
Aye.
and Chairperson Heather Miller.
Aye.
The vote is unanimous.
Okay, we're moving on to agenda item 3C, summary of enforcement cases with Sarah Bland-Linville.
Thank you. The chair again. For the record, this is Sarah Bland, petition case representative for the division. Before you are two default orders. No action is required by the board. I am available for any questions. Just to briefly summarize, Juan Ruiz is a third-time violator. So that's why his penalties are so high, in addition to the fact that there were so many particular violations on this one. And then the all types remodeling was pre a reinstatement case. So they had previously had a consent order that they violated by not continuing to pay the civil penalties that were ordered in there. So this one was a reinstatement of the suspended penalties, and it was default because they didn't respond to that notice, of course. If you have any other questions, please let me know.
Thank you. I do not have any questions about those cases. Anyone else? All right, agenda item 3D, the elevator program update with Mr. Hartung.
Good morning, Chair Miller, members of the board. For the record, Warren Hartung, Chief Elevator Inspector for the division. Typical report. The only thing different for us these recent months is access to facilities, which is quite limited. Spend a lot of time driving around knocking on locked doors. So that's a challenge. On the positive side, the airport's seen a reduction in accidents because of a reduction in travel. And it's much easier to get in there and do periodic inspections.
Silver lining.
Silver lining, yes.
Does anybody have any questions for Mr. Hartung? Thank you, sir.
My pleasure. Thank you.
Yeah. And we move on to agenda item 3E, the electrical program update with Keith Anderson.
Good morning, Keith Anderson, Electrical Program Chief. I have a couple things today. So as far as the adoption of the 2020 Oregon Electrical Specialty Code, it's been decided to move that out 6 months from the normal date of the October 1st out to April 1 of 2021. There's several codes, the plumbing and the residential codes have also done the same thing as extending it out. So we like to, the division likes to keep those aligned. The residential code adopts our code at the same time. So it was felt that it was important to maintain the time frames. The other item here is licenses. So, you know, due to the circumstances, the licenses that were to be renewed are going to be moved out here. So if your licenses was to be renewed between April and December of 2020, they're going to be extended out till January 15th. So, you know, nothing else has changed. The required continuing ed and all of that is the same. It just that it'll just taking place at a later date. So give things to give the division and people a little more time to prepare. So anyway, that's what I had for you today. If there's any questions.
Thank you, Keith.
Thank you.
Anybody have any questions for Keith?
Madam Chair, this is Thomas Kyle. We had quite a long submittal about some LED lights. Keith, are you going to come out with some kind of determination on that or comments?
Are you talking about the public comment this morning, or was this something else?
It was the written comment on those LED lights with the go in through a hole in the ceiling.
Yeah, I reviewed that. Those look like they're a retrofit setup. I don't really see any hazard issues or anything like that with what they're doing. It may not meet the letter of the code, but again, it's been certified through CSA, which they're on our list for providers, and it's been tested through UL. I'm not seeing, an issue with that. I think, if the person that provided that information still has some concerns, the place to take that would be to the listing agency and have a conversation with them on that. We have a number of examples of connectors and things. I think it's 334. 334.40. There's some other examples of splices that are approved for repairs that don't follow the normal code path, but again, they've run through the UL process and been approved to do what they're intended to do. So that's kind of where I got with that issue.
Thank you.
Welcome.
If there is no more questions for Keith, I can move on to agenda item 7A, new business. Andy Skinner is coming up to speak.
Thank you, Madam Chair, members of the board. For the record, my name is Andy Skinner. I am the Interim Enforcement Manager for the Building Codes Division. What you have before you today is agenda item 7A. This is a temporary delegation of final order authority in amended consent orders. Action requested, board to consider delegating authority to the administrator and the deputy administrator of the Building Codes Division to enter a final order in proceedings resulting in an amended order. So some of the background on this, as we all know, we've been in some unique times over the last several months, and there was an executive order that was issued by Governor Brown, 20-12, in response to the pandemic. This unique time has impacted a lot of Oregonians and has created some financial hardships for some of those Oregonians. So what this proposed temporary delegation of final order authority would do is it's first only applicable to already written final orders where the respondent has requested a payment plan adjustment solely to amend a previous final consent order, and would be in effect until the EO, the Executive Order 2012, is terminated by the governor. That would also terminate this temporary delegation. The total amount does not change that the respondent owes. And again, they have to request this. If this moves forward as an approval, we will need a signature from the chair on the second document that is in this agenda item 7A. I would be happy to answer any questions. This will take a motion.
This is Thomas Kyle. I make a motion to approve the proposed temporary delegation of final authority.
Randy Smith?
Aye.
Ryan Richards?
Aye.
Vernon Pomrose?
Aye.
Robert McNeil,
Aye.
Scott Hall,
Aye.
John Flagel,
Aye.
Randy Carmody,
Aye.
William Barlow,
Aye.
Vice Chair Thomas Kyle,
Aye.
and Madam Chair Heather Miller.
Aye. Excuse
Motion
me, aye.
passes unanimous.
Thank you, Madam Chair Miller and members of the board.
Andy, how do I get that? How soon do you need that signed copy?
As soon as you can get it to me, it should be in your packet. But I'm at home. Yeah, I just need a wet signature. You can email that and mail it. So if you want to get it to me sooner, you can email it and then mail the wet copy, please.
Okay.
Madam Chair, if this is easier, I'll just email you one right now.
Perfect. Thanks, Debbie. Okay, well, moving on to agenda item 7B, and we're talking about the reciprocity agreement with Washington for the general journeyman license. Todd Smith.
Yeah, good morning, Madam Chair, members of the board. Todd Smith, Senior Policy Advisor of the division. We are looking at the proposed reciprocity agreement for electoral journeymen with Washington. You saw this issue last about a year ago with some instructions that we could make minor modifications to the agreement to get it after you approved it, but you wanted substantive changes to come back to the board. In working with Washington, a substantive issue did come up regarding the approval of test scores for reciprocity. So that is why this issue is back before you today. Quite a bit has happened in the past year, so I will try to condense it as best I can. But mainly, the issue is that in Oregon, for a reciprocity license, you have to have gotten your testing score of 75%. In Washington, they require a 70%. So that's the main issue. Everything else, there were a few other minor changes that had to be done to work out some administrative differences between the states. One is that Oregon requires 6 months of work under the license before you can get a reciprocal license. Washington requires 1 year. And then there is a difference in how long the look-back period is for having taken a test and failed it in the state. So Oregon is 2 years, and I believe Washington has a rule for no failing of their tests. I will summarize the agreement, and then I will also let you know that Larry Vance from the state of Washington is also available on the phone to answer any questions. So under the agreement as proposed with the attached rule, you would need to have completed an apprenticeship. That's a minimum of 4 years, 8,000 hours, and 576 classroom hours. You will have had to have taken your electrical journeyman or equivalent test in Oregon or Washington with a passing score. You will have had to have worked under your license for the minimum amount of time in your reciprocal state, and then you'll required to have no violations or conditions attached to your license as required by the reciprocal state. So you have two things before you. One is the new draft agreement, and then the other is some changes to the draft rules that will be required to implement the agreement. I will need a motion for both of these, but I'm available to answer any questions if you have them. Brian Richards. I'm a little curious on why Oregon only requires 6 months of work versus Washington's 1 year. Can you add a little background to that, if you would? Yeah, so I can definitely do that. In our current reciprocal rules that exist already for other states, that is the minimum requirement. If you look at the rule in your packet,
It's 918-030-0045. One of the requirements is have worked a minimum of 6 months or 1,000 hours under the license of the reciprocal state. So we just kept that requirement the same for the new draft language to enact the one you agree with Washington. And then I will correct one thing I realized I skipped over, an important part. We had actually also asked for some public comment on this before the board meeting. I believe that was already sent to you as board members and is posted on our website as well.
This is Thomas Kyle. I was wondering you have the requirement for an apprenticeship, but this may have journeymen that have been a long time out of apprenticeship. Is there any provision for being more than 6 months past, or?
So that 6-month requirement is just a minimum. You just would have had to have worked for at least 6 months under your license. So if you worked for 20 years under the license, you would definitely qualify.
So in that case, you wouldn't have to prove that you finished an apprenticeship program?
No, you would still need to provide your certificate of completion from your apprenticeship.
This is Thomas Kyle. I'll make a motion to approve the Washington minimum exam score for reciprocity reasons and allow you to continue on with the rulemaking.
Randy Smith?
Ryan, I second.
Sorry. Randy Smith?
Aye.
Ryan Richards?
Aye.
Brennan Pomerose?
Aye.
Robert McNeil?
Aye.
Scott Hall?
Aye.
John Flagel?
Aye.
Randy Carmody?
Aye.
William Barlow?
Aye.
Vice Chair Thomas Kyle?
Aye.
Madam Chair Heather Miller?
Aye.
Motion passes by unanimous consent.
Did you say that we had something else to move on?
Well, I believe the motion that was made covers it. So there is the agreement itself and there's the rules. And he has made the motion to continue on with rulemaking. I interpreted that to mean that the board has approved the rules and the division can continue with the rulemaking process. If that is incorrect, please correct me.
No, I think that's correct.
Yes. Okay. Great. And also, I also just wanted to thank Larry Vance from Washington for being available and helping me get this before you today.
Yeah, thank you. Okay, now we're on to agenda item 7C, the board review and of committee recommendations for new continuing education courses and instructor applications, and Tyler Glaze.
Hello, members of the board. For the record, my name is Tyler Glaze, policy analyst for the division. If you can go to agenda item 7C, the amended version, it's amended document in red. You will notice that there are quite a few applications. These are applications received for the March board meeting that was canceled, as well as this board meeting. So in total, the committee reviewed 269 applications from 38 organizations. 114 of those courses were recommended for approval. 23 were recommended for denial. 125 instructors were recommended for approval, and 7 instructors were recommended for denial. And those are immediately after in your packet, item 7C. So if you have any questions, please feel free to let me know. And otherwise, Madam Chair, this will require a motion.
This is, through the chair, this is Rob McNeil. I have one question, which also ties in to the next item on the agenda. For Eric Paul Campbell, did he apply for his course to be approved for new continuing education? I didn't see it in there, but I may have missed it. Or Blue Phoenix Engineering, either one.
One moment, please.
I don't know if you have a search on there.
Tyler, this is Alana Cox from BCD. I thought my understanding was that he had been previously approved at a previous board meeting. Is that maybe the confusion?
Alana, this is Tyler Glaze, policy analyst for the division. I believe, if I'm remembering correctly, the course was already approved. And one moment. I apologize. Yes, I believe the course was already approved. It's not under Blue Phoenix. I believe it's under the E-Hazard Management LLC name. It's already an approved course for BCD. We just need to make sure that the application that he applied for his as an instructor is brought before the board, and the board votes on that.
Thank you.
Hi, this is Catherine DeSalle, Senior Assistant Attorney General. Good morning, everyone, Madam Chair, members of the board. If I understand what Tyler and Alana have been explaining, what you're looking to do is to ratify the approval.
Well, I think what we need to do is somebody needs to make a motion on agenda item 7C, and then agenda item 7D is the retroactive approval. So the first 7C is just to approve the recommendations for approval and denial for everything that's been put in front of them. The retroactive is a separate motion.
This is Ryan Richards. I would like to make a motion to approve item 7C on the agenda.
This is Ron Paul. Second.
Madam Chair, this is Tyler Glaze, policy analyst for the division. We actually need a motion to approve the recommendations of the committee or disapprove the recommendations of the committee, or amend it. It's one of those three options I think is the most clear.
This is Ryan Oak. I would like to make a motion to approve the committee's recommendations for approval.
This is Vern Palmos. I'd like to second that motion.
Randy Smith?
Aye.
Ryan Richards?
Aye.
Brendan Palmrose?
Aye.
Robert McNeil?
Aye.
Scott Hall?
Aye.
Joan Flagel?
Aye.
Randy Carmody?
Aye.
William Barlow?
Aye.
Thomas Kyle? Vice Chair?
Aye.
Chairperson Heather Miller?
Aye.
Madam Chair, this item was approved unanimously.
Thank you, Debbie. Okay, agenda item 7D is the retroactive approval request received from Blue Phoenix Engineering for instructor Eric Paul Campbell. Tyler, I don't know if you have any more to say about this, or we kind of talked about it before.
Madam Chair, this is Tyler Glaze, policy analyst for the division. No, I don't have anything to add. The letter from Mr. Campbell is just below the matrix for your review, and as well as a list of all the individuals that have taken the course.
I'd like to address the chair. This is Vern Palmrose. I personally have taken the e-hazard train-the-trainer course in Louisville, Kentucky, and if the Eric Paul Campbell taught the course as e-hazard has it laid out, I believe all the people that took the course got good electrical safety training. So I don't have a problem with approving those participants in the e-hazard safety training for both the low voltage and the high voltage as being good training, and I think it should be approved. So I'd like to make a motion that we approve retroactive approval request from Blue Phoenix Engineering.
This is Ryan. I'll second.
Randy Smith?
Aye.
Ryan Richards?
Aye.
Brendan Palmrose?
Aye.
Robert McNeil?
Aye.
Scott Hall?
Aye.
John Flagel?
Aye.
Randy Carmody?
Aye.
William Barlow?
Aye.
Vice Chair Thomas Kyle?
Aye.
And Chairperson Heather Miller?
Aye.
Madam Chair, this agenda item has been approved unanimously.
Thank you, Debbie. All right, one more retroactive instructor for, that's for the course. Sorry, the last one was for the instructor. This one is for the course, Blue Phoenix Engineering for E-Hazard Electrical Workplace Safety course, which Mr. Pomeroy said was a very good course.
Yes, I'd like to make a motion that we approve item E, for Blue Phoenix Engineering for retroactive approval of the safety course presented by Blue Phoenix Engineering.
This is Rob McNeil, I second.
Randy Smith?
I'm sorry, Madam Chair, I think we just flipped the order a little bit. I think the last motion covered this agenda item. Sorry, this is Alana Cox from the division. I think we need a separate motion to go ahead and approve the instructor on that. I think we just took them in reverse order.
The first one we did, the previous one we did was for the instructor. Vern talked about the course, but the motion, I'm pretty sure the motion was for the instructor.
Okay, my mistake. Thank you.
Randy Smith?
Go ahead.
Brian Richards?
Aye.
Brennan Pomeroy?
Aye.
Aye.
Robert McNeil?
Aye.
Scott Hall?
Aye.
John Flagel?
Aye.
Randy Carmody?
Aye.
William Borlow?
Aye.
Vice Chair Thomas Kyle?
Aye.
Chairperson Heather Miller?
Aye.
Madam Chair, this agenda item has passed unanimously.
Thank you, Debbie. Okay, so I'm going to read a short script for agenda item 8, the executive session. The Electrical and Elevator Board will now meet in executive session at 10:49 a.m. The executive session is held pursuant to ORS 192-6602F for this session, which allows the board to meet in executive session to consider information on records that are exempt from disclosure by law, including written advice from board counsel. Representatives of the news media and designated staff shall be allowed to attend the executive session. All other members of the audience are asked to disconnect from the audio conference board meeting. Representatives of the news media are specifically directed not to report on or otherwise disclose any of the deliberations or anything said about these subjects during the executive session, except to state the general subject of the session as previously announced. No decision may be made in executive session. At the end of the executive session, the board will return to open session and welcome anyone previously approved to join the audio meeting. So before we switch over to that, I need to make sure that Debbie, we're all good to go. Hang up from this call. Everybody go to the email you got from Debbie that has the GoToMeeting link and join that way. But Debbie, are we good to go?
Just one moment. I'm going to be disconnecting now.
Okay, the time is now 11:36. Debbie, will you recall the roll?
Randy Smith?
Here.
Brian Richards?
Here.
Brennan Pomeroy?
Here.
Robert McNeil?
Present.
Scott Hall?
Here.
John Flagel?
Here.
Randy Carmody?
Here.
William Barlow?
Here.
Vice Chair Thomas Kyle.
Here.
And Chairperson Heather Miller.
Here.
Madam Chair, you have all your members, and James Totten is still absent. You do have a quorum.
Thank you. Now we're moving on to agenda item 9, the board decision on enforcement case against Michael Cochrane. Does Assistant Attorney General DeSalle have anything to say now for the meeting?
I don't believe she's reconnected.
Okay. Well, was she supposed to?
I'll send her a message now to see if she wants to, but I don't think it's necessary.
Okay. So it's in the packet, and the board members know it's an old case that went to a default order, and they're looking to
Madam Chair, Thomas Kyle.
Yeah.
We'll make a
Thanks,
motion
Tom.
that we withdraw the final order on default for the William Cochrane case.
Ryan, I second.
Okay, I'll go ahead and take roll. Randy Smith,
Aye.
Brian Richards,
Aye.
Vernon Plumrose,
Aye.
Robert McNeil,
Aye.
Scott Hall,
Aye.
John Flagel,
Aye.
Randy Carmody,
Aye.
William Barlow,
Aye.
Vice Chair Thomas Kyle,
Aye.
and Chairperson Heather Miller.
Aye.
Madam Chair, this motion passes unanimously.
Thank you, Debbie.
You're welcome.
We have no announcements, and so we're moving on to adjournment. There being no further business, the meeting is adjourned at 11:39.